Thanks to reform efforts in recent years, Massachusetts has become a national leader in scaling back incarceration. But the number of people behind bars remains higher than it was 40 years ago, and a new study shows the state's criminal justice system is still marked by racial disparities. The study was done by the Criminal Justice Policy Program at Harvard Law School for the Chief Justice of the Supreme Judicial Court, the late Ralph Gantz. To tell us about the study are the program's executive director, Brook Hopkins, and a PhD candidate in public policy at Harvard, Felix Owusu. Thank you both very much for being with us. I want to start with Brook because this study was prompted by a request from Judge Gantz. We've been covering racial disparities in criminal justice for a number of years. What did the judge want to learn from this that he didn't know already?
Yes, well, you're right. Racial disparities in the criminal justice system in Massachusetts and indeed across the country is not really something new. This study in particular was inspired by some research that came out showing that the racial disparities in Massachusetts prison populations were quite high. And that's the end point. And what Chief Justice Gantz wanted to figure out was where along that process in the criminal system do those disparities arise? Are there particular decision points that contribute to those disparities more severely than others? And with that information, we're better able to target policy changes to tackle the disparities where they're arising.
Felix, a common oversimplification that comes up every so often is that where there are disparities in punishment, there must be disparities in crime. But as you've noted from this study, it isn't anywhere nearly as simple as that.
Absolutely, and thank you for having us and engaging with our work on this topic. You're exactly right that it is not just a simple story about sort of everybody's having punishments that correspond to the conduct. We, see in our analysis that even after you control for the severity of the charge and several other factors, racial disparities persist. And so that speaks to the fact that these disparities are large at the very beginning of the process before any adjudication happens and persist throughout the entire pipeline of adjudication and sentencing. Beyond that, we find that when you look at specific decision points and factors that lead to these sentencing disparities that we highlight, there are sort of key decision points that are not surprising to people who have followed sort of the historical development of our criminal justice system. So we highlight mandatory minimum sentencing and weapons and drug charges in particular, and the conversations around how we choose to punish those specific types of charges has been one that's been suffused with race throughout the history of that kind of charging in the state and the nation more broadly. And so it is not something that is as simple as this just corresponds to people's conduct. I think there's more of a story there. And I think a higher level story about what kinds of conduct we choose to criminalize at all and who we expect to be sort of suffering from those punishments as a result.
Felix, if you do a comparison, and you devote some time in the study to doing this, between gun charges and operating under the influence, both of these should be taken very seriously in any event, but what seems out of whack in the way those two kinds of crimes are treated?
Yeah, absolutely. We spent some time considering those kinds of charges, and as you mentioned, they both have very serious public safety implications and are things that should be taken seriously. But we do find, for example, that when you look at people who are charged with operating under the influence, basically drunk driving, there are a lot of options in terms of how to adjudicate those cases that involve education and a more public health oriented approach to solving those problems. And in many cases, those people are able to have their criminal charges dismissed as long as they comply with certain conditions. And when you compare that to something like unauthorized firearm possession, which again has public safety implications, but is not necessarily something that is immediately a danger, there's a much different approach to how those kinds of charges are adjudicated, and you see much less diversion, much less education, and much more incarceration in response. And so that speaks to a decision that's been made not at the level of individuals and how they're applying the laws, but what kinds of activities we use criminal justice and incarceration responses to solve versus other kinds of things that could be possible to address the underlying public safety concern.
One of the patterns this study uncovered was that I think Black and Latino defendants were more likely to have more serious charges, but also more likely to have those charges scaled back, maybe in a plea bargaining process. What do you take away from that?
Yeah, and so really that speaks to several potential explanations, and we sort of lay out what, possible interpretations are. We don't really observe the details of plea bargaining directly in our data, unfortunately, and it would be great to be able to add that to our analysis. But I do think it speaks to an interesting finding that even though people are getting charges that are in some cases more serious, when you look at what they are convicted of, you're not finding that it's more serious conduct. And in the case of Black people, it's actually slightly less serious than white people who are being convicted and incarcerated for those things. But those longer sentences that we highlight still persist. Right, so these initial charges are important, but they are leading to more intense consequences. But when you look at what people are actually able to be convicted of, that doesn't seem to track.
Brooke, in order to make these conclusions, you had to get hold of the data. What about the difficulties in getting it in the first place and getting it into manageable form?
Yeah, so this was a challenge, to put it mildly. It took us 4 years from the time when we first requested data till the time when we were able to publish this report. And a large part of that time was spent getting the data, cleaning the data, identifying problems with the data, requesting supplemental data in order to address those problems, and developing numerous workarounds to get around gaps in the data. So I will say that the criminal justice data systems in Massachusetts are outdated. They don't necessarily collect the data that is needed in a way that is available for researchers or accessible to researchers. And there was a lot of data we just couldn't get. We did not get enough law enforcement data, police data to analyze that part of the process. We did not get data from the district attorneys. We were unable to use most of the probation data because it is not linked to the trial court data in a way that allowed us to analyze it. And then there were data points even within the trial court data that we could not see. For instance, we could not see the final conviction offense for most of the people in our data set. And that is a huge gap, because that meant we could not really compare the sentences people were receiving based on their final conviction. Now, we were able to get a small portion of that information about final conviction offenses from the Department of Corrections, but that was only for a very small subset of our data set. So the state of the data in Massachusetts made this study extremely difficult to do, and we had unprecedented access. So I do think that should be added to the list of reforms, not just the reforms to the way that people are treated in the system, but also to the way that data is collected so that we can monitor what's happening in the system.
One thing this report left me wanting to still know more about is what happens to people on probation. They're going back to prison. What causes that, whether there's any pattern or disparity involved? Isn't it important to know more about that?
Yes, it is very important to know more about that. And probation across the country is kind of a black box. And we did receive data from probation. We were not able to tell from the combination of the probation data and the trial court data. We were not able to get a good handle on what was happening to people who were violating their probation and returning to incarceration of some form. So we can't really speak to that, and we can't really speak to lower level disciplinary decisions that are made on probation. And you're right, that is extremely important and something that we were unable to measure given the state of the data.
Felix, I've often heard prosecutors say they need mandatory sentencing only if for no other reason as a leverage to get somebody to plead guilty to another charge. It sounds like a race-neutral rationale, but take us further back in the history of racial sentencing, mandatory sentencing. What does it say about attitudes about race in this country?
I think when you see mandatory minimum sentencing, I see the historical progression of it as one that reflects, initially a desire to sort of remove discretion. And, one might think that could be something that eliminates racial disparities. But I think, as you said before, it's never quite as simple as that. And there's always more complication there. You're right that, people will argue that we need these, stiff sentencing possibilities to leverage guilty pleas. I think this is something that is actually interesting in that even when you look within people who are charged with mandatory minimums in our data set, there's still a racial disparity. It's actually quite large there, right? So it's not necessarily just a question of who is charged with them and who is not. which there is still a racial disparity in who's charged with them, but even within people who are charged with them, there's a disparity. We mentioned operating under the influence of drunk driving. Subsequent offenses of that, if you're a repeat offender in that category of crime, there are actually mandatory minimums that are available to be a sentence based on. They're often not used, right? People actually often will circumvent those and still have another option that's not involving incarceration, right? And so it's not just a story of these mandatory minimums tying people's hands. There are workarounds and ways to sort of divert around these kinds of things in the cases that people want to do. And so I think they don't sort of work exactly in the way that one might think without having seen these data.
Look, we usually think of at least the role of the judiciary as a matter of just, manipulating, not manipulating, but processing facts and interpreting laws as they exist, but not really changing them. In calling for this study, it seems, as somebody pointed out, Judge Gans used a lot of leadership capital here. Explain that part of it.
Well, I think for one thing, Chief Justice Gans recognized that we didn't have a good accounting of this in our state. And one reason for that is that it's very difficult to get the data. So when you have the Chief Justice of the Supreme Judicial Court asking Harvard Law School to do a study, and then that sends a message to all of the agencies that they need to share the data, that the trial court needs to, fulfill our data requests, that all the various agencies should give us as much data as they are legally allowed to give us. So I think that very first step was incredibly important for our ability to do this study. And then I think having his name behind this lent it a great deal of credibility and caused people to really take notice of what we found.
So what about you? Did this study, working on the study, change your perceptions of things in any way?
I think that the thing that this made very clear for me is that what we have right now is a system where data is collected for operational uses, but not really designed to be reviewed in a systematic way by researchers after the fact. And so those are dual purposes. What the person who's in court, building the docket day to day as cases happen needs to be able to see and observe to do a good job versus what somebody needs to be able to do to analyze 500,000 cases for racial disparities. Those are different tasks and require different preparation. I think now the conversation in Massachusetts is recognizing that those things both need to be taken care of, and we're moving in that direction. I hope this can help highlight the gaps that are there. And I think, as you said at the beginning, this is not a new set of questions, and I was drawn to doing this kind of work because I understand the problem is important. And so being able to speak to this with some amount of specificity and clarity, and also in some cases, I was surprised to see the number of things that lined up with what we've seen in other jurisdictions and other research, seeing the role of drugs, weapons, charges, mandatory minimums. Those are things that are not shocking, and I guess it was maybe reassuring to see that we're highlighting those same kinds of problems because there are solutions that we can think about. There's sort of tools that we can deploy to solve these problems. So that's, I think, my main takeaways from this.
Finally, Brook, it's a very interesting study with some very interesting observations, even tucked way down. So if people want to find this, can you tell them how they can pursue it online, maybe?
Yes. So the study is available on our website at cjpp.law.harvard.edu.
Great. Well, thank you both very much for being with us from your two different divisions at Harvard. This is Brook Hopkins and Felix Owusu. We'll have more news.
Thanks for having us.
Thank you very much.
We'll have more news in just a moment.